guns, and money.
So that'll take us, Dan, to our third topic. That is going to be the update in the Robert Kraft case. So for those that don't know, just a quick background. I had the ability to at least see most of these arguments. It wasn't so long ago. I believe it was maybe early July. But they posted the link live, and one of the benefits to living in this, probably Dan, the only benefit to living during a pandemic is that a lot of these things are on Zoom that you and I wouldn't otherwise be able to see live. So Zoom, credit to you. You've made the pandemic a little less worse. But for those that are kind of following this case, Robert Kraft was caught in a, we'll say a massage parlor, or whatever you want to call it. And as he was at the parlor, or whatever you want to call this, the spa, there was video surveillance being taken of the guests inside. So in order to get that access, that surveillance footage, there had to have been a subpoena that allowed that access. So as Robert Kraft left the facility, a police car found him and arrested him. And that is the nature of this case. So when the case was at the lower court, there was a battle over the evidence. And the question was whether that surveillance footage, whether that was allowed to come in, or whether it went beyond the police authority to conduct the surveillance, whether the subpoena didn't cover necessarily what it should have done. So that's what's called in the law, Dan, obviously the fruit of the poisonous tree, whether or not that should come in if it wasn't adequately covered by the police's authority. So that was ruled inadmissible at the trial court level. It went up on appeal, and that's the decision we're going to talk about today. Robert Kraft, if the evidence comes in, all of a sudden there's a pretty strong case at the lower court, but without that video, it's going to be really hard to prove that he was there, Dan. So why don't you fill us in on the update and where it goes from here?
Sure. This is a case that's not only about Robert Kraft, it was part of a series of consolidated appeals involving other defendants. And this is a case of first impression in the state of Florida. Florida court has never before answered the question that's been burning on our minds ever since we went to law school, which is, do you have a reasonable expectation of privacy in a massage parlor?
That is not burning on anyone's mind, Dan. Who do you think we're talking to?
Well, there are scant few cases in U.S. jurisprudence which assess the reasonable expectation of privacy in and around massage parlors. There's a case out of Maine. There's an Alaska Supreme Court decision.
Did you just say that question was burning on our minds since we got to law school?
Your mind, not mine, not mine.
You said our minds. I don't think like that. Don't bring me down to your level. Okay, keep going.
I only became married. I only married my wife a year ago. So up until a year ago, I never had any reason to go to one of these places. So I'm
just remember, this is all being recorded. Okay, just so you know, you have no expectation in privacy about what you're about to say. But go on.
So the truth is, the really fascinating thing about this case is that the Florida 4th District Court of Appeal ruled as a matter of law that a patron in a massage parlor, in a private public room in the massage parlor with the door closed, has a reasonable expectation of privacy under the Fourth Amendment.
As they should. You know, independent of what you're doing in there, if you're doing anything illicit or you're just getting a massage, God forbid, you should have an expectation of privacy.
Wait a second, this is not the massage room at Equinox. This is a massage parlor that is accused, or at least suspected, of being a front for a brothel. So you can call it a massage parlor, but if it's in reality a brothel, do you have a reasonable expectation of privacy in a place that has sort of a mixed use like that? Because some people go there for legitimate massages, some people go there for what I would call massage plus. And that's really a fascinating legal issue, which is why I believe this case might be headed to the Supreme Court of Florida, because it does impact the permissibility of law enforcement using these novel eavesdropping techniques, surveillance video in private/public places to catch people who are in the midst of committing crimes. Because with the crime of prostitution, the last element of the offense isn't committed until the money changes hands inside that public/private room. So without the ability to utilize this kind of surreptitious surveillance evidence, a lot of cases would fall apart. And I think it's important enough to the state attorney's office, because this isn't about Robert Kraft, but could potentially affect hundreds of cases going forward, not just those involving prostitution. So there's that issue. And then there's the issue of minimization techniques. The reason why the court found that the conduct of the state attorney violated the Fourth Amendment is that the the prosecution or the police officers didn't use sufficient or employ sufficient safeguards to minimize the intrusion on people going there for lawful purposes. So for those who went there for legitimate massages, well, they were caught on videotape as well. And Kraft was arguing the constitutional rights of others in seeking the suppression of this evidence. And I think it raises the question as to whether Florida law requires any of these minimization techniques, because there is no case law, no statute under Florida law that addresses this precise situation. It's only US Supreme Court precedent. And I know from litigating cases in Florida that it's textbook law that you do not have the right to assert the constitutional violations belonging to third parties. You can only assert the violation of rights pertaining to you. So I think this isn't the end of the story. This is what could be the beginning of a slightly bumpy road, which means that this could be in the news for another year or two, because we've got in my view, four gauntlets to run here. The state attorney will file undoubtedly a petition for rehearing en banc, to have the entire case reheard by the full Fourth DCA. 3 judges heard this case and decided this case. You're entitled to have the entire Fourth District Court of Appeal review it with all of the judges. So that move, or that next shoe, is going to drop within the next 15 days. And then afterwards, I would expect the prosecution or the sheriff's office to file a petition seeking review with the Florida Supreme Court. So I think these are teed up to be very interesting issues of first impression in the Florida courts, and I don't think it's anywhere near over yet.
So I have a question for you, Dan, because you had a question for me before. I don't know if I feel that strongly about it, but I think it's just worth bringing up for the purposes of the podcast. We talk about conduct detrimental. My general sense is that I think it's the worst kept secret in football and any type of sport. What a player does is going to get more scrutiny than what an owner would do, because the owner calls the shots, they run the show. At no point, as far as I'm familiar with, has Bob Kraft ever contested the validity of these videos, if it's actually him on video. I think he's pretty much owned it. So to the extent that this video, right, like it comes out or we all see it and he admits it in open court that it's him, is there any chance, in at least how you view this, that Bob Kraft could be in any way, shape, or form at risk of punishment, A, by the NFL, or B, the nuclear option, that he could potentially be at risk of losing the team?
Well, the latter is definitely not in play here, because if you were going to prosecute every septuagenarian who went to a massage parlor for sex, you really wouldn't have anyone left.
What is a septuagenarian?
Some guy in his 70s.
Oh, that sounded like
big
really
word.
inappropriate, but keep going. Yeah.
I
don't know what that meant.
Word. I don't think the issue is losing the team here. I think the bigger issue, besides the case and winning on the merits and getting this video suppressed as a matter of finality, is it's not just the criminal case that is at issue here. There's also the potential for parallel investigation by the National Football League. And let's not lose sight of the fact that a number of news organizations, including the Boston Globe, the Boston Herald, the Fort Lauderdale Sun-Sentinel, it's a very long list. They've made requests, Freedom of Information Act, public records requests for copies of these videotapes. And the Fourth DCA's ruling only addresses whether the video should be suppressed in the criminal case as a violation of the Fourth Amendment. We still have the looming issue over whether this videotaped evidence should be released to news organizations as a public record. And I could see the merits both ways. If you're Robert Kraft, it's fruit of the poisonous tree, an illegally obtained video in violation of one's constitutional rights should not necessarily be released to the general public. But on the other hand, the court's reasoning was based upon Fourth Amendment issues, not right of privacy issues. So I think we may be headed to another legal battle, not involving the NFL necessarily, but news organizations arguing that they should have access under Florida's broad public records law. And I think that aspect of the case may have a separate life of its own. And I'm not sure that the news organizations are in the wrong here. I think this is fair game as a matter of open and fair access of Florida's public records laws. And I think the merits or the equities lie on the side of open access rather than restrictions.
So I mean, we'd be remiss if I didn't bring it up. I mean, obviously, I don't actually think he's going to lose the team, but I do think punishment is in the realm of possibility. Jim Irsay, the owner of the Indianapolis Colts, had a DWI a couple years back, and he was found with pills in the car, enough that there was a reasonable expectation that he might have been selling them. I think it's, apples to oranges, whatever, metaphor you want to use here. But being caught in a massage parlor, doing whatever you were doing in there, whatever illicit acts you were doing with prostitutes, whatever, that's not a good look for an NFL owner. So I would be, if I'm Roger Goodell, I mean, you never know what Goodell's going to do. He's going to get bashed if whatever he does one way or the other. But I do think there's a very realistic chance that Kraft could get some type of suspension here. I think Irsay got a suspension for 5 games, and I believe it was a couple $100,000 in fines. So I don't think this is so. Maybe it's not as bad. I don't know how to compare the two. A DWI with intent to sell, prescription painkillers, or going to a massage parlor and doing something illicit. I think they're both in the category of things that you could get suspended for. So Dan, that's my prediction. And I'm going to nail both of these because I already got one, because I knew we were going to talk about Earl Thomas. Okay, Dan, I don't have anything else on this topic unless you do. I'm ready to wrap this third one up.
Yeah, I think Mr. Kraft is ready for us to move on as well, because we've just revived all these issues that are going to be lingering in his legal affairs for at least the next year or two, because this thing's not going away. And I would not be shocked if the result is different by the time the Florida Supreme Court addresses this. So
and
on that
no one's watching this on video, but Dan, the smile on your face, I thought you were about to give me some type of really fun metaphor involving Bob Kraft's case, but nothing here.
I'm going to leave that one alone.